Welcome, folks, to the Green Party United States Annual National Meeting 2012. This is the Thursday, July 15th, 2 p.m. session entitled Champion a Green New Deal for Voting Rights, Redeeming the Declaration. Our speaker here is Asa Gordon. The floor is yours, Asa.
All right, thank you very much and welcome, Greens, fellow Greens. This is just an idea, very simple, to kind of break through the noise on voter ID laws, that we promote something that actually a super voter ID law and make the challenge and take the front in guidance on this. So what I'm advocating is a Green New Deal for voting rights reformation that is found in the nation's founding declaration. The founding declaration being all men are created equal. And this was the theme that was used to redeem the Constitution by the Constitution era abolitionists, and their hierarchical focus was on the extension of the franchise. In fact, the extension of the franchise was to see that those who had been formerly enslaved would have the franchise. They went to the point of disfranchising the former Confederates to the extent that when registration for the first presidential election was completed, former slaves in the former Confederate states outnumbered the number of former whites in the former Confederate states to vote in the first presidential election. This was 3 years before there was a 15th Amendment to the Constitution. The irony is that we would have a 15th Amendment to the Constitution which grants the right to vote regardless of race, creed, or color, or previous condition of servitude, without having, in essence, extending to blacks the right to vote for a constitutional amendment for the right to vote. Because the majority of whites rejected those amendments to the Constitution. The only reason why we have a 13th and 14th and 15th Amendment to the Constitution is because ex-slaves were granted the right under the March the 2nd Military Reconstruction Act in 1867. In that act, disfranchised anyone who had pledged allegiance to the Confederacy. So by the end of registrations in 1867 for the 1868 presidential election, the majority of Southerners who registered to vote were former slaves, and they voted for the adoption of the 14th Amendment. So what I'm advocating today is GP advocacy in that spirit, to forthwith implement legislation for immediate, universal, and automatic voter identification and registration for all U.S. citizens of a state that files a federal tax return. Any state in which a federal tax return is filed is required to mail the citizen taxpayer a state-issued voter ID and mail in ranked choice voting ballots for the exercise of the franchise. If the mantra is, if the document is good enough to take my money, it's good enough to accept my vote. If it isn't, then refund all of my taxes paid. You don't require a photo to take my money, so you should not require a photo to take my vote. I introduced this as part of a senior program that Mayor Bowser had in DC, and her response was, that's not a bad idea. DC Mayor Bowser's response to a taxpayer, this is be called a Taxpayer Voter ID Act, which is automatic voter identification registration for all DC citizens that files a federal tax return. And I proposed this at the 2018 forum. I never heard back from the from her office. So this was so the idea is just universal automatic taxpayer voter registration ID and enforcement act pursuant to the malapportionment penalty of the 14th Amendment. Now, many of you who are attending this may not be aware of the malapportionment penalty of the 14th Amendment. I'm not going to go much into that now, only to tell you to Google Asa Gordon Electoral College, and you get all the information about my back presentation and civil actions regarding the second section 14th Amendment. which in essence penalizes states by reducing their representation in Congress in proportion to that citizens who have been disfranchised by any means. And that has never been enforced in our Constitution. And on its face, you can understand why. In Green Pages, I think it was the September 2014 issue, you go on and find a link to that, and you will find that I uh, wrote an article on this in the Green Pages called Asa Gordon Introduces Taxpayer Voter ID Act. And so it's a new voting rights law. The United States of America is founded on the principle of no taxation without representation. It stands to reason then that any document that is used by the federal or state government for taxation assessment constitutes sufficient taxpayer identification to register and vote for that government. A new voting rights judicial test. The Constitution mandated electoral partisan doctrine adjudicated under partisan vote abridgment of voting procedures as a standard unit. In other words, if you have partisan voter abridgment, then you are subject to the malapportion penalty of the second section. Voting rights origin, the hidden civil rights legacy of the Black Civil War veterans reconstructed. What it is that Black Civil War veterans advocated in order to secure their civil rights after the war. They were very instrumental in putting pressure on the Congress at that time, because they had served in the Civil War and helped save the Union, to pass and adopt the 14th and 15th Amendment to the Constitution. So here it is. The GPUS taxpayer voter ID ought to make we the people access to the franchise to form a more perfect union and eliminate lesser evil choices. If you go to the Facebook, I've posted posted this to the Green Party Facebook page, so you can go there and do a search on that. The GPUS taxpayer voter ID mantra is that any document that is used by the federal state government for taxation assessment constitutes sufficient taxpayer identification to register and vote for that government. If the document is good enough to take my money, it's good enough to accept my vote. If it isn't, then refund all my taxes paid. No photo is required to take my money. No photo is required to take my vote. The Green Party U.S. Taxpayer Proposed Voter ID Act addresses many of the pitfalls of the institutionalized and racially biased structure that presently exists for mail-in ballots as it presently exists. A study by MIT, Losing Votes by Mail, of uncounted mail-in vote put the loss at 22%. At 80% mail-in voting, 25 million would lose their vote. It should go without saying that the bulk of the loss would accrue to non-whites. However, there is no record of a 22% loss in people filing their income taxes regardless of race, color, or income. Any discernible lack of the IRS in being able to collect taxes from non-minorities. The Taxpayer Voter ID Act requires and funds states to provide postage paid return envelopes for ranked choice mail-in ballots to eliminate smaller votes. 8 states, including the swing states of Wisconsin, North Carolina, and I want you to understand much of the voter ID and voter suppression techniques that they are implementing in the states now implemented various means of this kind of thing in order to suppress the vote. In 2016, 8 states, including the swing states of Wisconsin, North Carolina, and Gorbachev's Minnesota, required double verification by mail-in voters to have the ballot signed by a witness. Taxpayer Voter ID Act, no double verification is required to take my money, no double verification to take my vote. 3 states, including swing state of Missouri, require the ballot to be notarized. Taxpayer Voter ID Act, you don't no notarized signature required when you take my money in taxes, so no notarized signature required to take my vote. Alabama requires a notary or 2 witnesses. Taxpayer Voter ID Act, No notary or two witnesses required to take my money. No notary or two witnesses required to take my vote. All but 6 states verify your signature against your registration signature. Partisan officials decide if there is a match. I don't know about you, but no one can read my signature. I can't even read my signature many times or match my signature on things that I sign. No less than 141,000 ballots were rejected as unmatched in 2016. Taxpayer Voter ID Act. No verifying tax with registration center is required for the government to take my money. No verifying tax with registration signature should be required to take my vote. In 2016, Ohio counted 385,065 registrations because these voters supposedly missed 2 federal elections. Taxpayer Voter ID Act. All Ohio taxpayers are automatically re-registered in the year federal taxes are paid. In 2018, Supreme Court in a 5-4 decision approved Ohio's massive records of inactive voters. Taxpayer ID Act. All active taxpayers are automatic reactivated voters. In other words, and simply what you're saying is, you cannot put there as the government more burden on me to vote than you put on me to take my taxes. If it's so easy
Right?
to take my taxes, then it should be just as easy and even easy for me to vote in a country that's based on the principle of no taxation without representation. Now, here's
Thank
what a taxpayer
you.
voter ID Act proposal would look like. This was a long title, an act to establish a national voter identification and registration standards for federal and state elections by taxpayers to enforce the 14th Amendment to the Constitution. Notice I did not say the 15th, but the 14th Amendment. I want you to understand that the first time the word citizen right to vote appears is in the 14th Amendment of the Constitution, not in the first, but in the second section. And it appears as a penalty against states who would disfranchise their citizens by reducing their representation in Congress. Be it enacted by the state, Senate, and Representative of the United States of America and Congresswoman that this act shall be known as the Taxpayer Voter Identification Act. Preamble. The United States of America is founded on the principle of no taxation without representation. Accordingly, any document that is sufficient to the federal or state government for assessing taxation constitutes sufficient taxpayer identification to register and vote for that government. Section 2. Any inhabitant of a state and citizens of the United States that files a federal or state tax return including dependents of voting age by regular mail or electronic filing, shall automatically be registered to vote in that state, and the state's Board of Division of Electors will provide a state voter ID card to all state taxpayers and their voting age dependents by regular electronic mail. Section 3. Any state that denies or abridges taxpayer voter registration and voter ID cards to citizens of the United States covered by Section 2 of this act is subject to the malapplication penalty clause of Section 2 of the 14th Amendment as implemented by Section 6 of Title 2 of the United States. If you look that up, Section Title 2 of the United States Code, Section 6 Title 2 of the United States Code is called the Reduction of Representation Code. Section 4. Nothing in this act shall prohibit any U.S. citizens of any state or territory of the District of Columbia from registering to vote in the traditional fashion with the applicable board or division of elections. This is not to replace or to be the total. This is just to augment and make easy voter registration, automatic voter registration, and voter ID. Section 5. The voter ID card issued by the states under this legislation shall be used for the purpose of identification at the voting polls only in the state in which it is issued. Now, when we file the income tax, you have attachment schedules that you can like Schedule B, Schedule A to the terms when you file your income tax. This would be what we call a Schedule TIVID, the Taxpayer Voter ID schedule. And this is how some the Office of Bureau of the Office Management of Bureau de, de, designs these type of attachments. This is a proposed design. As you can see there, you're putting your first name, your last name, the last 4 digits of the Social Security. You will put on there your date of birth, and you could put in there, click your party registration. If that is not one of the ones there, that you can write it in. And you put in your voting age dependents that appear on line 10-6. Everyone who files a 1040A or 1040, you can put in your voting age dependents on that form. Once that form goes in, a copy, every state has a copy of the attachments that you make to your federal tax. That is given over to the Board of Elections, and the Board of Elections is required to mail in everyone who is filed an income tax in that year, a registration and voter ID at the address registered on his at the time he filed his income tax. So all taxpayers will be updated at least by April of each year in which they are going to cast any vote in their state for any office. Now, one of the things we can argue is that in fact the National Voter Registration Act required, we can argue that the people who pay their taxes who are not being informed or given the ability to register before we go, if we have difficulty getting the Taxpayer Voter ID Act passed, is declared that the government, the state is not abiding by the National Voter Registration Act. When I contact the IRS, just like when I go to make use of any government entity, I should be allowed to give the opportunity to register to vote. It said, and here's the National Registration Act of 1993, also known as the Motor Voter Act, was signed into effect by the United States and Bill Clinton. However, compliance did not become mandatory until 1995. The legislation required state governments to allow for registration when a qualifying voter applied for renewed their license, applied for social services. That's a social service. When you any social service, Medicare, whenever you put it, they are not doing this. For instance, with the American Medicare Act, they should be registering everyone who applied for any social service. All right, provisions of this act. The legislation was initiated to reduce costs of voting registration by accumulating individual data when apply for driver's license or renewing social assistance. You notice that they go to the Department of Motor Vehicles to check as a means to see as a voter ID for registration. The most people have filed an income tax whether they drive or have a motor a license or not. So why not go the same information? You have more information that you give to the government when you file your federal income tax than you do when you file to get a license or renew your license. So why not go to that database to determine whether or not you should be registered to vote? Because they know that's universal. That's almost automatic. They rely on the motor voter, the license, because that in essence have a disproportionate impact. Now, here's in Arizona that this is the National Voter Registration Act requires to use a uniform form that does not have on there, that does not require a photo ID, and it only requires that you affirm under penalty that you're a citizen. Hell, Arizona's evidence of citizen requirement as applied to federal form applicant preempts the national mandate that states accept and use the federal form. In other words, Arizona, they wanted to only allow people to vote who can prove that they were citizens. But there was the elections board sent out a form for registration that only require you to check a box that says I am a citizen. This court, the court has already ruled that the National Voter Registration Act form that just requires that a citizen merely indicates on the penalty that he is a citizen overrides any state form that would make additional requirements like a photo ID, a verified signature. Here's what the voter registration of the Election Assistance Commission voter registration application. And you look on that, you can see name, ID number. That could be your last 4-digit social security number. There's no requirement here of you supplying a photo. There's no requirement here of you having a verified signature. There's no requirement of having notarized signature. There's no requirement of two signatures, etc. That has been already ruled, even by this conservative court, that it takes precedence over any state form. What is happening here is actually the National Voter Registration Act has many things that can implement what a tax voter ID Act was if it was being enforced. I don't understand why civil rights organizations are not they're going more to the Civil Rights Act of 1865 or the Voting Rights Act, which has been gutted. But the National Voter Registration Act is a powerful act that's being overlooked. I think the Green Party in every one of these states should research the National Voter Registration Act and challenge that these suppression laws are violating the spirit and intent of the National Voter Registration Act, and that we want to pass a Taxpayer Voter Registration Act to augment the National Voter Registration Act intent by making automatic registration and voter ID for every taxpayer, citizen taxpayer. Look at here's defining the purpose of the National Voter Registration Act. Congress finds that the right of citizens of the United States to vote is a fundamental right. It is duty of the federal, state, and local governments to promote the exercise of the right. 3, discriminatory and unfair registration laws and procedures can have a direct and damaging effect on voter participation in elections for federal office, and disproportionately harm voter participation by various groups, i.e., like green voters, or socialist voters, or whatever, including racial minorities. Now, how is it any of these voter suppression laws is consistent with this finding under the National Voter Registration Act? Purposes of the National Voter Registration Act: to establish procedures that will increase the number of eligible citizens who register to vote in elections in federal office. How can any of these voter suppression laws meet that standard of B 773 of the National Voter Registration Act purposes, Section B, to make it possible for federal, state, and local governments to implement this subchapter in a manner that enhances the participation of eligible citizens as voters? How can any of these voter suppression laws in any of these states be consistent with this section of the National Voter Registration Act? The Green Party in each one of these states need to be forefront in forcing civil action of making these voter rights acts, saying that suppression acts in these states are inconsistent with the existing National Voter Registration Act. And to augment the National Voter Registration Act, we need to pass a Taxpayer Voter ID Act for automatic registration voter ID for all that file their taxes. Also is to ensure that accurate and current voter registration rolls are maintained. So don't get all hung up on the Voting Rights Act. We already have a strong act. You know, organizations are about that. They ignore strong laws that's already on the books. The conservatives keep on guessing, make you think you need new laws, you need new. Every time they violate a law that's on the book, you got to get a new law to enforce the law that's already on the books. All right. Mail registration. Each state shall accept and use the mail voter registration application form prescribed by the Federal Election Commission. So you just put pressure on the Federal Election Commission to put out a form that does not require photo ID, that does not require double verification of votes, and say that is consistent, has been consistent with the history of the National Voter Registration Act. And these laws that are being passed in these states are inconsistent with the form Section A of 1973 of mail registration under the National Voter Registration Act. 2, in addition to accepting and using the form described by paragraph, a state may develop and use mail voter registration form that meets all the criteria stated in the section. A form described shall be accepted and used for notification at a registered change of address. Availability of forms. The chief state election official of a state shall make the forms described in Section A of this section available or distribution throughout government and private entities, with particular emphasis on making them available for organized voter registration programs. So Greens in all these states can break through the noise as being advocates of strong enforcement and showing how these laws are in violation of the existing National Voter Registration Act, and advocating for a universal, strong, super American taxpayer voter citizen ID Act for all people who file their federal income tax, automatic registration. Now, this argument came up. Obamacare voter registration was criticized in the left and right in January. Civil rights organizations say the healthcare website doesn't fully comply with the federal law and may miss registering millions of eligible voters. Some of the right think it shouldn't register voters at all. The Green Party in each one of these states where they're passing these suppressions should be bringing attention to the failure of all of the state agencies in their state that provide service are in violation of the National Voter Registration Act and not making it ease the process for those who are applying for service. Not just people who are going to renew their license, but who are abiding themselves of any government service, including the IRS. Two liberal rights groups say that the Affordable Care Act may not be in compliance with a federal law and are urging the Obama administration to change how enrollees are prompted to register with the newly created federal insurance program. There is a day and night difference between what is required by law and what the administration has done. Under the National Voter Registration Act, known as the Motor Voter Act law, we're going to change it to the Taxpayer Voter Law. States are required to provide eligible citizens, i.e. taxpayers, an opportunity to register to vote when they apply for and renew their driver's license, or pay taxes, change their address, or apply for public assistance. Because the ACA's health insurance is changed to provide public assistance in the form of Medicare, because the IRS provides assistance if you ask them how to fill out your form, you should also be at that time required to give you an opportunity to register to vote. And philosophically, the NIR applies, the voting rights advocates say. The Obama administration agrees that the Affordable Care Act needs to comply with the motor voter law and has taken some steps to give. Saying that I want you to understand that it is still in many areas where the Affordable Care Act is being applies, which is all the states now, is not fulfilling its provisions to provide opportunity for those who take advantage of, who use the Affordable Care Act, the right to be registered to vote. The Greens should be at the forefront. You can break through the noise of Greens in all of these states be out front in seeing that this is being done. The National Voter Registration Act. Congress enacted the National Voter Registration Act, known as the Motor Voter Act. We're going to change that to Taxpayer Voter ID Act to enhance voter opportunities for every American. The act was made it easy for all Americans to register to vote and to maintain their registration. The National Voter Registration Act allows the Department of Justice to bring civil actions. We should be, the Green Party in each one of these states should be petitioning the local Department of Justice to ensure, to give them assurance that the laws being implemented are not only concerned with the Voting Rights Act, with the government, which has been gutted by the Supreme Court, but whether or not they are inconsistent with the National Voter Registration Act, and also expand the National Voter Registration Act to include a taxpayer voter the Green Party Taxpayer Voter ID Act.
We have that socialism all the way down on Obama.
All right. I'm hearing cross noise now. The act also gives the responsibility to the Federal Commission to provide states with guidance to develop a national mail registration form and to compile reports on the effectiveness of the act. Section 6 of the act provides that citizens can register to vote by mail. National Vote Registration Act, Section 6 of the act provides that citizens can register to vote by mail using mail-in forms developed by, we're going to say, include Taxpayer Voter ID Act for each state and Election Assistance Commission. Why isn't that being done? Why isn't that being enforced? Taxpayer Voter ID Section 7 of the act requires states to offer voter registration opportunities at all offices that provide public assistance. The Green Party in each one of these states should be advocating and insisting and ensuring that this is being done. IRS Citizen Taxpayer Voter ID Act, when people free application for student aid, when your kids are filing for free application for federal student aid, under the National Voter Registration Act, they should also be given the opportunity to register to vote for a party at that time. Each applicant for any of these servants, renewal of servants, or address changes must be provided with a voter registration form of a delegation form, as well as assistance in completing the form, and forward the completed application to the appropriate state or local election official. Argument of all the Green Party and all these states have said none of these laws that are being passed are consistent with a federal law that's already on the book. Now, how did we get into this mess? Where am I on time? Oh, 29 minutes, okay. The first structural, systematic racism in our voting procedures was at the Constitutional Convention in 1787. William Lloyd Garrison passed this resolution: resolved that the compact which exists between the North and the South is a covenant with death and an agreement with hell, involving both parties in atrocious criminality, and should be immediately annulled. This resolution was drafted by the abolitionist William Lloyd Garrison and passed by the Massachusetts Anti-Slavery Society. The compact to which it referred was the Constitution of the United States of America. The compact was declared an agreement with hell because in its original form, it sanctioned slavery. Now, let me pause here to tell you that I'm a plagiarist. I believe in plagiarizing, because if you ain't plagiarizing, you're making stuff up. Everything I'm going to tell you, I am plagiarizing from history. I am not going to give you one original thought of things. I am giving you information that is simply being ignored. This is from, at the Constitutional Convention of 1787, there was an official note taker. He's sometimes called the father of the Constitution, James Madison of Virginia, who also was instrumental in the drafting the Constitution of Virginia, and he was instrumental in instigating the first Constitutional Convention of 1787. And here is the entry in his notes of the Federal Convention by James Madison at entry of June the 30th. The states were divided into different interests, not by their difference of size, by other circumstances, the most material of which resulted partly from climate, but principally from the effects of their having or not having slaves. These two causes occurred, concurred in forming the great division of interest in the United States. It did not lie between the large and small states. It lay between the northern and southern. Yet, if you Google the National Archives or the History Channel about what is the main differences, they talk about large and small states. The guy was there who took the notes, who was the founding father, said these two causes, the principle was on the effects of having or not having slaves, not large or small states. In his entry of July the 14th, quote, it seems now to be pretty well understood that the real difference of interests lay not between the large and small, but between the northern and southern states. The institution of slavery and its consequences formed a line with discrimination. So says the father and note taker at the Constitutional Convention. Here's an entry of 1917 that gets to how the Electoral College came about as a means of institutional bias in order to give disproportionate representation to white minorities in southern states to checkmate a white majority that may undermine the maintenance of slavery in the Constitution. Mr. Governor Morris, it is necessary to take into one view all that relates to the establishment of the executive. One great object of the executive is to control the legislature. The legislature will continue to seek to aggravaze and perpetuate themselves. It is necessary then that the executive magistrates should be the guardian of the people, even of the lower classes, against legislative tyranny, against the great and the wealthy, who in the course of things will necessarily compose the legislative body. Wealth tends to corrupt the mind and to nourish its love of power and to stimulate it to oppression. History proves this be the spirit of the opulent. Who can judge so well of the discharge of the military duties of the protection and security of the people as the people themselves who are to be protected and secured? He was talking about the people should make the decision. But here, Mr. Madison, there was one difficulty, however, of a serious nature attending the immediate choice by the people. The right of suffrage was much more diffusive in the northern than the southern states. In fact, in some of the northern states in New Jersey, women could vote. In some of the northern states in New Hampshire, they were talking about even some free blacks could vote. And the latter would have no influence on the judgment score of Negroes, that is, the southern states who had a slave population who couldn't vote. Here it is. The substitution of electors alleviated this difficulty and seemed, on the whole, to liable the fewest objections. The substitution of electors was precisely to, to give disproportionate representation to the slave-holding southern states to checkmate a white free majority that may try to undermine the slave-holding power. Here is how the population estimates were made at the Philadelphia Convention of 1787. Uh-oh, what happened? It seemed like I was disconnected. Can you hear me?
Yes, I can hear you.
Okay, I'm sorry. It seems like, disconnected. All right. This is a table that was actually used at the Constitution of 1787. And what they the table was used to do, they had to estimate what was the non, you know, the non-white populations in certain states. They used this table to determine what would have to be the percentage that they would have to assure that the southern states would have a checkmate by requiring a supermajority extra representation by being able to count their slaves in the electoral college and in the Congress in order to checkmate a majority that may try to undermine slavery. And so here are the estimates you see at the point. You say the total population estimate in Maryland, Virginia, North Carolina, and South Carolina of what the colored population in those states. They were satisfied. Now, what is remarkable is that the first census took place in 1790. Look how close it was, how, how close some of those estimates were at the Constitutional Convention were to the first census in 1790 of the colored population in those southern states that insisted on counting what? 3/5 of their slaves who could not vote for the purpose of giving them extra representation in Congress to checkmate any attempt to undermine white supremacy or slavery. That was the origin of the supermajority. The origin of the supermajority was at the Constitutional Convention to give disproportionate affirmative action articles for a white minority to checkmate a white majority that may try to undermine slavery or the institution of slavery at that time. All right, we have a security. So sufficient were these affirmative action articles deemed at the Constitution. General Charles Pitney, who was a delegate from South Carolina, said, "We have a security that the general government can never emancipate them, for no such authority is granted. And it is admitted on all hands that the general government has no powers but what especially granted by the." Anybody know what that is? That's the 10th of argument. The 10th Amendment was put in place, the state's argument, to ensure that the jungle had no powers and that it would never be able to emancipate them. James Madison Wilson, who was a delegate from Pennsylvania, and he participated in the Free Fifth Clause. Can we forget for whom we are forming the government? Is it for men or for the imaginary beings called states? So here are Article 1, Section 2, Clause 3, and Article 2, Section 1, Clause 2 are the two affirmative action articles that to ensure and give disproportionate power to the slave-holding states. They are affirmative action articles built into the Constitution. So if we want to talk about systemic racism was built into our Constitution of 1787 to provide disproportionate affirmative action articles by the Free Fifth Clause to those states that wanted to preserve and maintain slavery and white supremacy. Article 1, Section 2, Clause 3. Representing direct taxes shall be apportioned among the several states which may be included within this union according to their representative numbers, which shall be determined by adding to the whole number of free persons, including those bound to serve for a term of years, excluding Indians, not taxed, 3/5 of all other persons. Here is the electoral college. Each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the number of senators and representatives to which the state may entitle. That incorporated the Free Fifth Clause into the electoral college. So here are the Constitution's white minority privilege quotas of 1787, affirmative action articles for white supremacy that is built into the Constitution. Article 1, Section 2, Clause 3, establish an anti-majoritarian calculus for congressional representation that favored the minority white slave-holding population of the South by counting its slave population. This disproportionate race quota was entrenched into the fabric of the original Constitution of 1787. Article 2, Section 1, Clause 2. This clause provided for the indirect election of the president through the Electoral College based on congressional representation. This provision incorporated the Three-Fifths Clause into the Electoral College and gave whites in slave states a disproportionate influence in the election of the chief executive. This actually was implemented, this disproportionate law was actually part of the basis of Bush's versus Gore, which decided that the individual citizen has no federal constitutional right to vote for electors for the President of the United States. The source of that statement is in McPherson versus Bracken in 1892, that the state legislators' power to select the men of appointing electors is preliminary. Now, do you know that what is going on in all of these states now, where they're talking about passing law where the legislature can determine who the electors will be, irrespective of how the people voted? You know what they are relying to? They're relying on this McPherson versus Bracken case that was decided in 1892. The same court that 4 years later decided the Pleasant versus decision, establishing legal apartheid in this country. That is what is going on in the state in these suppression laws today. The 15th Amendment exempted citizens of the United States. This is what McPherson versus Bracken ruled in 1892 and was the basis of Bush's versus Gore. The right of the vote in the states comes to states, but the right of exemption from the prohibited discrimination comes from the United States. The first has been granted and secured by the Constitution of the United States, but the last has not been. What that relied on was two cases, U.S. versus Contract and U.S. versus Reese. Those two cases, U.S. versus Reese, the 15th Amendment does not confer the right of suffrage upon anyone. It prevents the states of the United States from giving preference in this particular to one citizen of the state. U.S. versus Contract. We decided that the Constitution of the United States does not confer the right of suffrage upon anyone. What I'm trying to make you understand is Bush versus Gore relied on two Supreme Court decisions that were decided to overturn Reconstruction and reestablish white supremacy. That is the two cases that is determined, that is taught in law school as the two most racist decisions that was ever rendered during Reconstruction. That is the basis of Bush versus Gore, and that is the basis for the ruling that is being made now, sustaining state suppression laws. Rehnquist was a lawyer in private practice in Phoenix for 16 years and became well known among local Republicans for his outspoken opposition to school integration. In 1952, Rehnquist clerked for the Supreme Court Justice Robert H. Jackson and wrote a memo arguing that Brown versus the Board of Education, then pending before the court, should be decided against the plaintiffs in favor of allowing so-called separate but equal schools. We're talking about the Chief Justice of the Supreme Court for Black and white students. When Chief Justice Warren Burger retired in 1986, President Ronald Reagan appointed Rehnquist as Chief Justice. As a Supreme Court Justice, Rehnquist's track record has dramatically conservative. When Bush versus Gore changed from an election to a series of lawsuits in 2000, Rehnquist was instrumental in first delaying the Florida presidential recount of 2000, then ruling that time had run out. In stopping Florida officials from conducting a recount, Rehnquist's Supreme Court ruled 5-4 that a recount would irreparably damage the legitimacy of Bush's probable Confederacy. Months later, unofficial recounts conducted by several different newspapers showed that under almost any standard proposed at that time, Al Gore had won more votes than George Bush in Florida. The High Court in Bush versus Gore held that the individual citizen has no federal constitutional right to vote for electors for the President of the United States. It is no consequence that this reaction decision is based on the extreme decision of another right-wing Supreme Court. The Bush relied on a decision written by Chief Justice Wilson Fuller in McPherson versus Bracken, which held that state legislators had plenary power to select presidential electors. The Fuller Court was among the most notorious reactionary in history. In 1896, the Fuller Court issued Pleasant versus Ferguson, the precedent that enshrined the doctrine of separate but equal, thus institutionalizing Jim Crow segregation. In 1905, gave us Lockett versus New York, which created the doctrine of substantial due process in order to strike down state laws seeking to protect the health, safety, and wages of workers. Like most Fuller Court jurisprudence, the McPherson is completely out of line with contemporary notions of democratic rights. As with Pleasant and Lockett, its result hinges on a complete distortion of the 14th Amendment, which was ratified to guarantee people their democratic rights to due process law and equal protection. Section 2, not 1, the Equal Protection Clause, but Section 2 of the 14th Amendment expressly prohibits the right to vote, including the right to vote for the choice of electors for president and vice president. This was from the cartoon guide of the Constitution of the United States. And it said the right to vote was first recognized in the new improved census created in the 14th Amendment, Section 2. Article 15 in that same cartoon guide of the United States says, it is rare indeed when the Supreme Court calls the Constitution a lie. In 1864, election official named Reese refused to let registered black voters vote. The feds sued. The opinion in U.S. versus Reese is a wonder to behold. There is no right to vote. Since it doesn't exist in the first place, it can't be denied. Election officials can do whatever they want. I want you to understand that McPherson versus Bracken is the basis of the Supreme Court that is behind all of the suppression laws that are being passed today in Bush's versus Gore. The last ex-slave to serve in Congress warned us of this when he was removed from, when he left office in 1896. White was elected to Georgia. He was a member of the U.S. House of Representatives from North Carolina, 2nd District. While campaigning against, he campaigned against racial discrimination and urged the enforcement of the second section of the 14th Amendment that reduced the representation of the House representative of those states which denied African Americans to vote. In addition to campaigning for anti-lynching legislation, George White challenged the House to punish southern states for disfranchising blacks by calling for a reduction in their congressional delegation. White's appeal in 1899 that southern delegations to Congress ought to be limited to the benefit of votes that are allowed to be cast in their representation initially fell on unsympathetic ears. Despite his declaration, it is a question that this House must deal with sometime sooner or later. Derived from Section 2 of the 14th Amendment, reduction legislation required Congress to penalize states that sought to disqualify eligible voters by subtracting the number of disfranchised voters from the population count used to determine the number of seats each state was allowed in the House. The Green Party should be educating the public to this issue throughout all of these states in which these voting suppression laws are taking place. At the high tide of radical Republican rule in the House, the chamber passed a measure after the 1870 census that required Congress to enforce that provision. Section 6 of the voting rights of eligible male inhabitants over the age of 21. The number of representatives opposing this act to such states shall be reduced in proportion which the number of male citizens shall have been to the whole number of male citizens 21 age of the state. In other words, you can't count people that you will discharge in your state for the purpose of how many representatives you will have in Congress and deny them the right to vote for them representatives. If you do that, then you will have to, by Section 2 of the 14th Amendment, reduce your representation in proportion to that population that you have disfranchised. At the turn of the last century, Congressman George Henry White, the last former enslaved black to serve in Congress, and by 1898, the only African American in the House of Representatives, challenged the House to punish Southern states for disfranchising blacks by calling for a reduction in their congressional delegation. Congressman White appealed in 1899 that Southern delegations to Congress ought to be limited to the benefit of the whole votes that are allowed to be cast in their representation. On May the 8th, 1866, during the debate on the 14th Amendment, Thaddeus Stevens, the leader of the Republicans in the House of Representatives, delivered a very important speech on the amendment's intent. He said, I can hardly believe that any person can be found who will not admit every one of these provisions of the 14th Amendment is just. They are all asserted in some form of on our Declaration of Organic Law. The abolitionists referred to any law that was inconsistent with the Declaration, the Declaration being the what they call the organic law, the Declaration being all men are created equal and endowed by the Creator with certain inalienable rights. So the whole Reconstruction was to bring the Constitution back in alignment with the nation's founding, quote, declaration. The second section I consider the most important in the article. It fixes the basis of representation in Congress. If any state shall exclude any of her adult male citizens from the effective franchise or abridge that right, she shall forfeit any right to representation in the same proportion. The effect of this provision will be either to compel the states to grant universal suffrage or so shear them of their powers to keep them forever in hopeless minority in national government. This provision of the Constitution has never been enforced, and no legal organization, liberal, conservative, otherwise, has ever filed a suit to try to enforce this provision of the Constitution. If you want to find anything on this matter about Google Asa Gordon Electoral College. Now, what is behind all of this effort to disfranchise us today? It is the fear of what they call Negro domination. This is from the Afro-American in 1859. The Ohio Black Law unconstitutional. In essence, what this judge ruled is that a law they had on the books that denied a black who tried to register to vote who had some white blood in him was unconstitutional because he could prove he had some white blood. And so he allowed, in essence, he declared that law unconstitutional. As a consequence, a lot of blacks in Ohio said, even if you have an inch or drop of white blood in you, register to vote. And here's what was carried in the Richmond Enquirer of November the 2nd, 1860, just prior to the Lincoln of the first presidential election proceeding on the dawn of the Civil War. Ohio carried by Negro votes. The Philadelphia, Pennsylvania says that the returns of the Ohio election disclosed the fact that the Republican majority was only 8,794. 14,000 Negroes were allowed to vote. And under the decision of state of Judge Breckenridge, leaving out the Negro vote, the Democrats had a majority of nearly 6,000. Thus, the startling, the humiliating fact appears that Ohio, a southern state of this union, is under Negro rule. To such a disgrace would the black Republican Party reduce the whole country. This thing is too shameful, too sickening, too revolting to contemplate. The election. The Philadelphia election throughout the Union is over. And the people have learned by means of the telegraph that the black Republican ticket. Now, there were no black Republicans on any of the Republican tickets. Why did they refer to the black Republican ticket? Because the votes of blacks made a difference in checkmating or overcoming the majority wish of the whites at that time. Thus, for all intent and purpose, blacks ruled by their vote. headed by Abraham Lincoln of Illinois and Hamilton Hammer of Maine, has triumphed. From the beginning to the end, this has been a central contest. The entire North, excepting perhaps the states of New Jersey and Delaware, has gone for the black Republican candidates, while the entire South has cast its strength against that ticket. We shall now enter upon any argument to show what should or what will be the measure of the people of the South will adopt to preserve their rights in the Union or to secure Southern independence out of the Union. The Facts of Reconstruction is a book that everyone should be required reading. It was written by John Lynch and was the first African American Speaker of the House in Mississippi. He was also one of the first African Americans elected to the U.S. House of Representatives during Reconstruction. And in his chapter, he asks, what constitutes Negro domination? What answer he gives here is the same thing that is affecting all of the politics that is going into the voting suppression laws in our time. It is claimed that in states, districts, and counties in which the colored population people are in the majority, the suppression of the colored vote is necessary to prevent Negro domination, to prevent the ascendancy of the blacks over the whites in the administration of the state and local governments. And this brings us to the consideration of the question, what is meant by Negro domination? The answer that the average reader would give to that question would be that it means the actual physical domination of the blacks over the whites. But according to a high Democratic authority, the Democratic Party at that time was what the Republican Party is today, okay? That would be an incorrect answer. The definition given by that authority I have every reason to believe is the correct one, the general accepted one. The authority referred to is the late Associate Justice of the Supreme Court of the state of Mississippi, H.H. Chambers, so in an article in the North American View, March 1881, explained and defined what is meant or understood by the term Negro domination. According to Judge Chambers' definition, in order to constitute Negro domination, it does not necessarily follow that Negroes must be elected to office, but that in all elections in which white men may be divided, if the Negro vote should be sufficient decisive to be potential in determining the result, the white man or men that would be elected through the aid of Negro votes would represent Negro domination. In other words, we would have Negro domination whenever the will of a majority of the whites would be defeated through the votes of colored men. That is what is driving all of this voter suppression today. The fear of Negro domination that goes back to the 1890s. If this is the correct definition of that term, and it is no doubt the generally accepted one, then the friends and advocates of manhood suffrage will not deny that we have had in the past Negro domination, nationally as well as locally, and that we will have it in the future. If that is the correct definition, then we are liable to have Negro domination not only in states, districts, and counties where the Negroes are not in the majority, but in states, districts, and counties where they are few in numbers. If that is the correct definition of Negro domination, then the suppression of that vote is not only necessary in states, districts, and counties in which the blacks are in the majority, but in every state, district, and county in the Union. In this connection, it cannot and will not be denied that the colored vote has been decisive in potential in very important national as well as local and state elections. For instance, the presidential election of 1868, General Grant, the Republican candidate, lost the important and pivotal state of New York, a loss which would have resulted in his defeat if the 7 states that took part in that election had not all voted against him. That they did not do so was due to the votes of the colored men in those states. Therefore, Grant's first administration represented Negro domination. That is the first election of the first president following Reconstruction represented the will of the black population over the majority will of the white population. And the South has never forgiven that. Why the South must prevail. This is national view of William Buckley, who's considered an icon, intellectual icon of the conservative movement. He writes in the National Review, the central question that emerges is whether the white community in the South is entitled to take such measures as are necessary to prevail politically and culturally in areas in which it does not prevail numerically. The sobering answer is yes. The white community is so entitled because for the time being, it is the advanced race. It is not so easy and is unpleasant to adduce statistics evidencing the cultural superiority of the white over the Negro. But it is a fact that obtrudes, one that cannot be hidden by ever so busy egalitarians and anthropologists. National Review believes that the South's premises are correct. It is more important for the community anywhere in the world to affirm and live by civilized standards than to bow to the demands of the American majority. Doonesbury hits home with a few cartoons to lighten it up here a little bit. Says, how's it going, white guy? Glad, Jim. Sure do appreciate the sending hours on the outside of town. Hey, folks, Jimmy Crow here. As you can imagine, have been very busy lately stamping out voter fraud. I've been reducing polling sites and cutting early voting rolls, all my personal fags. Checking voter IDs. Oh dear, valid. Oh, why am I sweating it these days? The coast, they keep calling my good work voter suppression. If you can't limit voters who make bad choices, it will be a disaster. It's got me worried sick. Hey, gerrymander. No worries, Jimbo's got your back. And this is another cartoon I want to go over that. I think I'm running late here. It says such a voter suppression alone enough for us to win future elections. Gerrymandering, roll purges, ID laws, registration hurdles, disinformation, early voting cutbacks, unequal resources, casting less, really getting the job done? Clearly not. It's time to get serious and double down with state by state election rigor. So there's been some soul searching. Yeah. You can't just keep doing things the same old way, right? Party affiliation. Better get some guidance on that. Hi, I'd really like to register to vote, but I'm not sure what party is right for me. I'd be happy to help you with that, sir. Tell me a little about yourself. Well, I'm a small business owner. The pandemic's bankrupt me. I have no health insurance and can't pay the mortgage, make the mortgage payments. A house with no power that just got flooded again. And thank you, climate change. And I'd like to start over, but I still have a massive student loan debt. So what do you think the primary role of government should be? Owning the libs. You a Republican, just put your square heads here. So the fear of Negro domination is at the core of all these voter suppression laws. The Green Party should be advocating a new judicial test that's predicated on the second section of the 14th Amendment. Voting right is inherently implicit and subjective under the adjudication of the equal balance test under the Equal Protection Clause of the first section of the 14th Amendment. The Green Party should be advocating voting rights is quantitative under the adjudication of a partisan abridgment test under the Malapproachment Clause of the second section of the 14th Amendment. In other words, gerrymandering, we argue, is primarily a violation of the United States Constitution, Article 4. What we should be arguing that any voting law or procedure that results in a disproportionate abridgment of votes by race in our party affiliation is in violation of the second section of the 14th Amendment. Any state that implements any voting procedure that imposes an improper partisan resulting in a disproportionate electoral bias that favors a particular political party or racial group is subject to the Malapproachment Penalty Clause of Section 2. But to set this all up, we should be advocating a taxpayer voter ID act, automatic registration and voter ID for all citizen taxpayer, no photo ID required to take my money, no photo ID to take my vote, no notarized signature required to take my money, no voter register, required to take my. In other words, no additional requirements should be made on a citizen to vote than you required to take his money to pay his taxes. There are two articles that I would refer you to reference that goes into detail on this, and that was an article that I wrote in Green Pages, Volume 7, Summer Issue of 2013, Asa Gordon's case for democratizing electoral college. That gives an article mainly about the second section, 14th Amendment, and the Volume 18, the Summer Issue of 2014. I'm sure there's a link to it somewhere on the Green Pages. And go to this. Asa Gordon introduces Taxpayer Voter ID Act. And I'm at this point, I'll open it up for comments or questions. I'm gonna stop the share. Is that okay?
Yes, very good. This is Lou here. There's a couple of questions in the chat from Gil Obler. He first asked, how can those who do not file federal taxes also get this ID? And then he goes on to ask, would this act override disenfranchisement of parolees who pay federal taxes in states which currently do not allow them to vote?
No, it's not meant to replace all the traditional means that are available to register to vote. That's still available for those, to those citizens. What this meant to do is to augment and automate the greatest number of registration, ease the registration for those who pay their taxes. Even people who don't pay their taxes, you file a federal income tax to show that you don't have make enough money to pay taxes. It's called, and so it's not meant to replace, it's meant to augment. It's saying a taxpayer voter ID act in which the state is required to mail every taxpayer who pays state taxes or federal income tax a voter ID. He's automatically registered to vote when he filed his taxes, and he's entitled to a voter ID. And they have to mail him, the way the Greens will be arguing, he should be mailed a form that is a ranked choice form in the mail. But no, it's not meant to, it's meant to augment. It's not meant to replace any existing means for registration.
If anybody else has a question, you can unmute yourself and ask, please. Go ahead, Anna.
And yes.
For HR1, SR1, I think some of the Senate, I heard that some of the senators felt it was unconstitutional. Do we know anything about that?
What, HR1?
The People's Act?
I don't know what would be unconstitutional about it. As a matter of fact, it's unconstitutional to the extent that it's not going far enough. You would have to be more specific. I'm not sure what provision of the act they're saying that is unconstitutional. All right.
Right.
But what I'm advocating is that we need to break through the noise as Greens. The Greens should say, okay, you want taxpayer, you want voter ID? We'll give you voter ID. We want universal automatic registration for everyone who files federal tax in your state. All the information there's. Why do you go to the Department of Motor Vehicles to determine what kind of information is needed for me to be registered to vote? All the information that I filed at the motor vehicle is when I file my taxes. So that when you file your federal income tax, when you file state income taxes, the state just copies much of the information that you filed in your federal income tax. So what we are arguing is everyone who is filed or paid taxes in the state should automatically be registered. And they should be sent a registration voter ID. That would be mad. There's no voter registration drive we can do. And here's the kicker. In the form that we're assisting in the Taxpayer Voter ID Act, it will list that you attach to your 1040. It will list all of the parties. So there is no voter registration that the Greens could do that would be easier than when someone gets fill out their 1040, they see a form that has the Green Party has a little box there that they can check and automatically be registered in the Green Party or any party. So that's why they don't want this, because it automates the registration process. So you would have all you have to do, a party would have to do is educate everyone. Look, when you fill out your taxes, tell them you want the taxpayer voter ID form and you want to be accrued the opportunity to register to vote. And the form that, if you go to my website, Google Asa Gordon Electoral College, and you'll eventually get to my web page. The form that I'm saying that you attach, you will fill out which your party you want to be registered in. And the government, and the requirement is on the government to send you. They have no problem sending you, sending you rebates for your tax. They have no problem finding you when they have to take your fine. So the Taxpayer Voter ID Act is just a means to automate registration voter ID, and quite frankly, to make it easy for third parties to be registered, to register a large number of voters for a third party without going through a signature drive. And here, see, the other thing is, the Green Party can say, okay, I want under the Freedom of Information, I want the information of everyone who checked the box of the Green Party when they file the income tax. You already will have the statistics that you need, understand the statistics you need in order to have enough in that state registered, to have to be registered in that state to vote. There's no other way you can make it easier for a third party to be registered than having a universal automatic registration form that is attached to when you pay your taxes. You have that opportunity. Now, the other thing I'm arguing is that Green Party should be everywhere in these states, should be looking closely at the National Voter Registration Act and arguing that the National Registration Act has provisions are being violated by all of these proposals in these state voter ID laws that is being posed, repression laws that's being supposed. Did I get to you? But as far as the HR one, I'm not sure what act they would be talking about is illegal in that.
Asa, could I ask a question?
Yes.
Hey, as usual, you have a very enlightening presentation, really extremely interesting. How important has your proposed legislation been shared with anybody in Congress, particularly the squad? Has there been any interest shown by anyone in Congress now?
The only one that showed an interest in that, he died last year. He was the aide to Bobby Scott. And so I'm trying to get back to Bobby Scott, because I do have a little in with him. Where, I'm with the National African American Civil War Memorial Museum, and we're working on a memorial together. And so I'm going to use that. I'm trying to use that as leverage to get to him on this Taxpayer Voter ID Act proposal. But
have you been in contact with anybody in the squad?
In the what?
The squad, the most progressive people in Congress.
No,
I would suggest you consider doing that.
Yes.
Sharing your bill with them and get something going.
Lou here again.
Yes.
We've run out of time, but that sounds like something all of us should perhaps be doing, not just letting the squad know about the Voter Taxpayer ID Act, but letting our legislators know and taking it before Congress. It seems to me to be a no-brainer, right? If the Voter Act is something that everybody can buy into, this should be as well. Asa, thank you very much. It was a very informative and enlightening presentation. I hope everybody who attended enjoyed it. But I'm going to close out the session and start out the 3:30 session, which will be commencing in about 8 minutes. Thanks again, folks, and take care.
Right. Okay, I was about on time.